Landlords, do you know the penalties if you fail to comply with deposit regulations? Deposit registration came into force in the private rented sector on the 6th of April 2007. It was brought in to protect landlords unlawfully withholding tenants' money. In 2007, when the legislation came into force, a landlord had to register a tenant's deposit with a government-approved scheme within 14 days of receipt. They also had to provide to the tenant something called prescribed information. Prescribed information gives tenants the details of to where their deposit is held, how much the deposit is for, and how they can retrieve their deposit at the end of tenancy. This was changed in 2012. And the current rules are now a landlord has 30 days to register the deposit with a government-approved scheme. Currently there are 3 schemes: the Tenancy Deposit Scheme, known as TDS, the Deposit Protection Scheme, known as DPS, and My Deposits. All 3 schemes offer 2 types of schemes: an insured scheme and a custodial scheme. All of these schemes are acceptable for deposit registration. The difference between an insured scheme and a custodial scheme. An insured scheme means a landlord would register the deposit with the scheme and hold the money throughout the duration of the tenancy in his bank. A custodial scheme means that the landlord would register the deposit with the scheme but pay the money to the scheme for them to hold throughout the duration of the tenancy. All deposit schemes come with adjudication as an offering to tenants. So, at an end of the tenancy, if a landlord and tenant cannot agree to the disbursements of the deposit, then after trying to negotiate, the landlord and/or the tenant has the option to take the dispute to arbitration. Landlords, when making a claim from a tenant's deposit, you must remember that the scheme will always view the money as the tenant's money unless you can prove otherwise. This means that when a tenant moves into a property, you absolutely must have an inventory, which is a condition of the property at the start of tenancy. You then also, at the end of tenancy, must have a checkout report. This, along with other evidence that you provide, will be what's used to adjudicate whether or not the deposit is returnable to the tenant or whether you, as the landlord, are entitled to any of that funds based on your claim made. Over the years, I've seen many landlords be unsuccessful when claiming from a tenant's deposit, not because they were not due the money that they were claiming. It was quite simply because they had not had an inventory at the start of tenancy, and therefore the deposit scheme provider has no evidence of the condition of property at the start. And therefore it is very difficult as a landlord to prove you are owed money when there's no starting position. This, in my opinion, is one of the most important pieces of legislation that you have to get right. Because if you fail to comply with the 30-day deadline, there is no way we can rectify the problem. We unfortunately cannot turn back time. So let's look at the requirements of deposit registration. A landlord must register a deposit with the schemes mentioned previously in this video within 30 days of receiving the deposit. Please note, I have said 30 days of receipt of the deposit, not 30 days from the start of the tenancy. It is vitally important that the deposit is registered 30 days after receipt, regardless of when the tenancy starts. Secondly, you must ensure that you are providing the tenant with prescribed information. This must be provided to them within the same timescales, within 30 days of receipt of the deposit. The prescribed information should be signed by you as the landlord or your agent. You must also provide to the tenant the deposit certificate where applicable to the scheme, and/or the terms and conditions, and/or the leaflet. Each scheme has different documentation, so be sure when choosing a scheme you are issuing all relevant documents to the tenants within the 30-day timescale. One more thing to note about deposit registration and the compliance. It is important that you know who paid the deposit. It may well be that you're renting to a tenant and the parent is paying the tenant's deposit on their behalf. If this is the case, You must treat this person as a relevant person. They must be named on the deposit registration documents, and all documents mentioned must be served upon the relevant person as well as the tenants. If you're finding this video useful, please subscribe to our channel where you can find more videos about compliance and legislation in the private rented sector. Earlier, I said that I feel this is the most important piece of legislation to get right. The reasons behind this are not only financial, but let's look at the penalties for failure to comply from a financial point of view. If you fail to register a tenant's deposit within the 30-day timescale and provide them with all of the relevant information and documentation, a tenant can take you, the landlord, to court, and the judge may well award up to 3 times the deposit amount as a financial penalty. More importantly, however, you may well lose your right to gain possession of your property. If a deposit has not been registered within the given timescales, you may fall foul when serving Section 21 notice on your tenant. You may arrive in court reliant upon the notice that has been served. However, a judge, if picked up during the court hearing, could question why the deposit was not complied with as it should be, and your case may well be thrown out. There are also cases that I have been party to whereby we were taking a tenant to court on a Section 8 notice. The tenant had failed to pay their rent and they were more than 2 months in arrears. The tenant went to the citizen's advice and made a counterclaim against the landlord for failure to register the deposit. Now, the deposit had been registered. The tenancy was a 10-year tenancy. There was 1 week in between change of agents where a deposit was unprotected. Because the tenant had made a counterclaim, the judge awarded the penalty of 3 times the amount of deposit to the tenant. This meant that our Section 8 was now null and void because the rent arrears were no longer above 2 months. Because the landlord had been awarded to pay the tenant a sum of money, that was counteracted against the arrears, meaning the whole process could not continue. An agreement was made in court that it was the one and only time that the tenant could pursue the landlord for failure to comply with the deposit regulations. And at a later date, we served Section 21 notice on the tenant and obtained a successful possession order. However, this took several months more than it would have done if we were successful with the Section 8, and also a great cost to the landlord with the financial penalty, whereby she had to write off rent arrears that was owed to her. This is a time-sensitive matter and you cannot turn back time. So landlords, please ensure you are getting the deposit registration correct. One more thing I would like to add to this section of deposit registration. Deposits, as of the 1st of June 2019, have been capped at 5 weeks. Landlords cannot take a deposit that is greater than 5 weeks' rent. The calculation must be used correctly and can be found in the description below. So landlords, please do not fall foul to these regulations. Comply with the deposit regulations and keep yourself safe and protected. I do hope you enjoyed this video. I do host a quarterly webinar where we cover all other varieties of legislation within the private rented sector and dig deeper into those individually. Please do feel free to register by clicking the link below in the description, and I hope to see you there soon. If you would like to continue to learn more now, we have a playlist dedicated to compliance in the private rented sector. So please do click here now.